Welcome to Know Your Data, a podcast by the Irish Data Protection Commission. With the date for the UK's EU exit approaching, and like everything else, data protection will be impacted in some way. In this episode, I'm going to take you through what Brexit means for organisations that transfer personal data from Ireland to the UK. Firstly, we're going to look at what will happen if the UK leaves the EU without a deal. So in essence, with a no-deal Brexit scenario. Flows of personal data to and from the EU are necessary for international trade and cooperation. However, the transfer of such personal data from the EU to controllers and processors located outside the EU in third countries should not undermine the level of protection of the individuals concerned. So a third country is any country outside of the European Economic Area or the EEA. Therefore, transfers to third countries or international organisations should be done in full compliance with the GDPR, that is the General Data Protection Regulation. In data protection terms, the UK will become a third country post-Brexit. So what this means is that the transfer of personal data from Ireland to the UK will be treated in the very same way as transfers of personal data to countries such as Australia or Brazil, just to name a couple. In practice, this means that in order to comply with the GDPR's rules, an Irish organisation intending to transfer personal data to the UK will need to put in place specific safeguards to protect the data in question in the context of its transfer and subsequent processing. This can be done in a number of different ways, depending on the circumstances in which the data is transferred. One such way is the use of standard contractual clauses, or again, they're known as SCCs. And this is likely to be relevant to most Irish businesses that transfer personal data to the UK. These SECs consist of standard or template sets of contractual terms and conditions that the Irish-based controller and a UK-based recipient, who often acts as what's known as a data processor, both sign up to. The idea is that each of the parties to the contract gives contractually binding commitments to protect personal data in the context of its transfer from the EU or EEA to the third country. And what's important here is that the data subject is also given certain specific rights under these standard contractual clauses, even though they are not party to the relevant contract itself. The standard contractual clauses can be adopted by putting in place a standalone contract or a new contract between the Irish-based controller and the UK-based recipient. Another option is where the Irish-based controller and a UK-based processor already have a contract in place between them, which is a requirement under the GDPR. They can incorporate a standard contractual clause into the existing contract. This is provided that its terms do not affect the standard contractual clauses or reduce the data subject's rights, and provided its terms do not reduce the level of protection which the UK processor is required to provide for the transferred data. You can find a simple set of standard contractual clauses on our website at www.dataprotection.ie, as well as an overview of the contents of the standard contractual clause. You can also find out more information about international transfers on our website. It is also important to bear in mind that standard contractual clauses and any of the other mechanisms used to facilitate the lawful transfer of data out of the EU or EEA are not an end in themselves. It's important to ensure that transfers are conducted and managed in a way that ensures that personal data is protected as set out in the GDPR, and that the obligations assumed by the parties under the terms of their standard contractual clauses contract are carried out in practice. So what if a deal is agreed between the EU and the UK? It was originally envisaged with the negotiated withdrawal agreement that there would be a transition period whereby the current regime would apply to transfers to the UK and that no additional transfer tools would be needed. However, if a deal is agreed and the transition period is a part of it, well, this could allow sufficient time for the European Commission to adopt an adequacy decision in respect of the UK. So finally, if you're not sure about any of the terms that I've used here in this podcast, you can find a list of definitions of key data protection terms on our website at www.dataprotection.ie. You can also check out the Irish Government's dedicated website for all Brexit information at www.gov.ie/Brexit. This has been Know Your Data, the Irish Data Protection Commission's podcast. And don't forget, you can find us on Twitter and Instagram at DPC Ireland and on LinkedIn. Thank you for listening.